a lethal weapon in the hands of the adversary to enable him effect the demolition of the case of the opposing party. It is therefore good practice for counsel not only to put across his client's case through cross-examination, he should, as a matter of the utmost necessity, use the same opportunity to negative the credit of that witness whose evidence is under fire. Plainly, it is unsatisfactory, if not suicidal bad practice, for counsel to neglect to cross-examine a witness after his evidence in chief in order to contradict him or impeach his credit while being cross-examined, but to attempt at doing so only by calling other witnesses thereafter. That is demonstrably wrong and will not even feebly dent that unchallenged evidence by the counsel leading evidence through other witnesses to controvert the unchallenged evidence. Now, you can see that by my Lord's pronouncement, cross-examination is an art, and that is what makes the topic itself apt. Therefore, it is how good an artist is that will determine how beautiful his artwork will be. Nobody can tell you that this is the way you should carry out cross-examination. But everybody can tell you what the objective of cross-examination should be. If you read, for instance, the pronouncement we just reviewed, one of the objectives of cross-examination will then be that it is aimed at attacking the credibility of your opponent. You are to use it to test his accuracy, veracity, or credibility, and then use it to shake the foundation of his case. In fact, you could use cross-examination to even build your own case. Now, how do you achieve that? If you watch several movies pertaining to law, but the one that I will give for illustration is a movie called My Cousin Vinny, you will realize that amongst the witnesses lined up was a lady who uses glasses. The lawyer got information that she couldn't see from a very far distance. And then when she was in the stand, all he needed to do was to go to a particular distance and ask her to identify whatever thing he was showing. Then he was showing his fingers and she couldn't even see. They were merely in the courtroom, and she claimed that she saw the defendants in that case from some meters away from her house. Immediately, he was able to demonstrate that she couldn't see very well. All the things that she had said in chief went away. Therefore, for you to be able to achieve the mastery of cross-examination, you must fundamentally know your case, and then know the case of the defendant, or if you are the plaintiff, or know the case of the plaintiff if you are the defendant, and then see how you could use it to demolish the case. Note, it is quite easy for you to demolish the case of your opponent if you know your case. You know, it has always been said that when a good lawyer is one who knows the law, but the one who wins a very difficult case is the best lawyer. Thus, your task of showing that you are the best lawyer is best achieved during cross-examination. For truly, a person could have a very good case, but you could with a very good art of cross-examination, destroy that case. So I give an illustration. Mr. A comes to court and says that, oh, on day ABCD, the following event took place. After narrating the event, he come and is quite detailed. He will look very educated. You will think that he's quite tacky. But you could start by asking him about his date of birth, if he could remember. You could also ask him other information, not necessarily related to the case. And this is where you may have some fight with judges and lawyers on the other side. They will say cross-examination is no longer, the sky is no longer the limit to cross-examination. Yes. But if you look at section 223 of the Evidence Act, this is what it says. It says when a witness is cross-examined, he may, in addition to the questions referred to in the preceding sections, I'll come to that preceding section, be asked any question which tends to test his accuracy, veracity, or credibility, or B, discover who he is and what is his position in life, or C, shake his credibility by injuring his character. With this, you could respond to anybody who thinks the sky is no longer the limit to cross-examination, that your questions are asked within this limit, so that if you put your questions within these limits of the law, nobody can prevent you. Therefore, you could destroy a person's evidence who may be giving evidence about a particular event, but you are able to show that in previous occasions, he has been identified as a liar. Therefore, there will be no reason why anybody will think that at this time in these proceedings, he is not lying. Many a case have been lost and won during cross-examination. There are so many things you can ask during cross-examination, like during examination in chief. And let us go to the Evidence Act. And this is what it says. It says, listen to section 221. Any questions suggesting the answer which the person putting it wishes or expect to receive is called a leading questions. It's a leading question shall not be asked in examination in chief or re-examination, except with the permission of the court. Therefore, it means that you could ask leading questions during cross-examination, right? Then said the court shall permit leading questions as to matters which are no. Leave that. It says leading question may be asked in cross-examination. It's even clear. Now it says a witness may be asked under examination whether any contract, grant, or other disposition of property as to which he is giving evidence was not contained in a document. And if he says that it was, or if he is about to make any statement as to the content of any document, which in the opinion of the court ought to be produced, the adverse party may object to such evidence being given until such document is produced, or until facts have been proved which entitle the party who called the witness to give secondary evidence. I'm sorry, this section is not relevant. It's this section that I wanted to talk about. Evidence of using previous testimony to destroy a witness evidence in chief. Just a moment, please. Let me just bring out the section. Yes, section section 231. It says if a witness upon cross-examination as to a former statement made by him relative to the subject matter of the trial and inconsistent with his present testimony does not distinctly admit that he has made such statement, proof may be given that he did in fact make it. But before such proof can be given, the circumstance of the supposed statement sufficient to designate the particular occasion must be mentioned to the witness, and he must be asked whether or not he has made such a witness. Then say a witness may be cross-examined as to previous statement made by him in writing or reduced into writing and relative to matters in question in the suit or proceedings in which he is cross-examined without such writing being shown to him or being proved. But if it is intended to contradict such a witness by the writing, his attention must, before such writing can be proved, of such contradictory proof given, be called to those parts of the writing which are to be used for the purpose of contradicting him. I'll give a personal experience. So we were conducting a case at the trial court, and this witness had deposed to a witness statement on oath in their initial statement of defense. But when they filed their statement of defense, we now got information from their defense that seemed to strengthen our case. And then we applied to the court to amend our statement of claim. The court granted us leave, and we amended our statement of claim. When we amended our statement of claim, they were asked to file a consequential statement of defense. When they filed the consequential statement of defense, they proceeded to abandon all of the evidence which supports our case that they had made in the previous witness statement on oath. Now, you know the law is that a witness statement on oath that is not adopted is not evidence. So we were stuck because we cannot compel them to adopt a witness statement on oath that they are not willing to utilize. So relying on this section, we started by asking the witness questions about, oh, you had previously deposed to a witness statement on oath. Yes. Oh, first confirm to the court that all what you have said here is correct. Yes. And at the time you were stating all those information too, all what you were saying to the court then is correct. Yes. Say, okay. Now, look at this portion of your witness statement on oath. Is it consistent with this other one? Then objection was taken, an argument was rendered, and the court admitted that we could rely on that witness statement on oath. And it was with that witness statement on oath that we were able to show that the witness is giving inconsistent statement, and the court ought not to rely on that statement. And eventually, yes, the court agreed, and the Court of Appeal affirmed the decision. There was no appeal to the Supreme Court. Therefore, as you rightly said in the topic, cross-examination is truly an art. Being an art, it should be utilized with good skill. And in the course of utilizing it, you must do it with a lot of mastery and tactics. How do you gain mastery? One way of gaining mastery is by reading several books on cross-examination. There are both local and international authors on this point. They assist you in understanding what it is that you should do and how to do it to get the best effect. Now, for tactics, I see many lawyers, they come to court and they already have their questions written. That could be an accepted module. You could say, oh, yes, okay, question 1, tick, question 2, tick, question 3, tick. But for me, I don't use that question. I use objective. So you say, okay, what is the objective you want to achieve? So with that, you will not find yourself in a cul-de-sac if you ask maybe a direct question that you have asked, and the witness did not give you the answer that you are expecting. So probably you may best use objective rather than specific questions, because more often than not, I find lawyers find themselves in cul-de-sac where they ask a question, they are expecting a particular answer, but they don't get it. One thing you must know is that during cross-examination, you should be careful not to allow the defendant use that avenue to build up his case, or the opponent use that avenue to build up his case. So they say that do not ask a question that you do not know what the anticipated answer is, so that you do not give the defendant or the opponent the opportunity to build a case he was not able to build during his examination in chief. I see many a lawyer do that, particularly when they come to use leading questions, and then they ask questions that allow the other party to just go. So, for example, it is advised not to use the word how, because that will entitle the witness to do a lot of explanation. Not to use the question what, because it will allow the witness to do a lot of explanation. Or the word where, because this is you giving him room to do a lot of explanation. And in the course of that explanation, he could build up whatever it is he has destroyed. Now, that saying in English that you should know when the ovation is highest, because that is the time that you should walk out of the stage, applies during cross-examination. When you go in, you behave like a thief. Go in, take what you want swiftly, and get out. Don't stay too long. If you stay too long, you could destroy whatever it is you have achieved. It's very, very fundamental that your questions are short, your questions have target, and you know what it is you want to ask. Note that, yes, it is true that an unchallenged evidence must be accepted by the court, except if that evidence is what the court calls moonlight. Therefore, if your evidence that you see, you say, oh no, I don't want to not cross-examine this witness, so I have to cross-examine him. But maybe the guy comes and says that, oh, the capital of Nigeria is Lagos. You wouldn't need to cross-examine that kind of witness. You could just at best let him go. Because if you cross-examine him, you say, no, it's a typographical error. It was Abuja I meant. So I want the court to help me. It's Abuja I was talking about. And so you have made him build up the case. So if you do not need to cross-examine a witness, please don't. There is no advantage in cross-examining a witness. It's very, very important for you to note something. Oftentimes, people go to court without having a clue as to what they want to achieve with the cross-examination that they want to do. It is very fundamental for you to know the goal you want to achieve. And as I said, once you achieve that goal, please let it go. Don't say, oh, let me ask this other one. No, let me ask this other one. No, you don't need that. Now, there is a question that lawyers often ask. Could you tender document during cross-examination? The answer is in the affirmative. And the authority I have for that is the case of Gaji and Baye, 2003 Law Pavilion Electronic Law Report 1300 Supreme Court. And the court said, when there was a ruling that, oh, evidence obtained during cross-examination is inadmissible, the court said, It is a new learning to me that evidence procured from cross-examination is inadmissible. Evidence procured from cross-examination is as valid and authentic as evidence procured from examination in chief. Both have the potency of relevancy, and relevancy is the heart of the admission of in the law of evidence. Where evidence is relevant, it is admissible and admitted whether it is procured from examination in chief or cross-examination. Therefore, the saying is true that you could actually prove your case during cross-examination, that you may not even need to call evidence if during cross-examination you are able to put your case through. And that we see when we are doing election-related cases. You find that they will say, oh, only the petitioner called his case. The respondent did not call any witness, yet the petitioner lost. This is because during cross-examination, you will be able to discredit the witness. I'll give another illustration. So we had a situation where a witness came and gave evidence regarding the fact that elections were not conducted in certain polling units in certain places. And he said, oh, it was because the election were not conducted. That was why he was not able to get any result. So during cross-examination, we tendered the documents that they had that had a list of all of their agents. And he accepted and said, yes, this is the list of all of their agents. And he was the one that signed it. So I asked him, oh, is there the name of Mr. ABCD on that list? He said, yes. I said, what polling unit did that Mr. ABCD supervise? He said, oh, he supervised polling unit EFD. Then say, okay, thank you very much. We now tendered the polling unit result of the place where that witness supervised. And it was his name that was there and he signed. So we gave it to him, say, confirm that is the name of that man that is in that polling unit. He said, yes. I said, confirm that the man signed the result. He said, yes. I said, confirm that that is election result of that polling unit. He said, yes. Has case not finished? Therefore, it becomes very important that you know that you can tender documents through cross-examination. Now, note, and that's why I said you must know when to stop. Do I need to ask that witness? It shows from this document that you are lying. I don't have to. Those are legal conclusions that I have to reserve during address. So I don't have to say, it shows that you are lying. He said, no, I'm not lying. That document must be forged. It is concocted. We don't have it. Blah, blah, blah. You have opened up something that you have already closed. You know, lawyers, we used to have this moral issue, and they used to ask me all of the time that lawyers, you used to defend, you used to postulate that what is white is black and what is black is white. No, that has never been the task of the lawyer. The task of the lawyer is advancing the case of his client. And in advancing the case of his client, this is what he does. A lawyer should not deliberately say that what is black is white. But a lawyer is entitled to prevent his opponent from proving that what is white is white. I hope you are able to understand the distinction. I should think that I should stop here, although I realize that I'm not giving a timeline, but I think we have already done 44 minutes inside the program so that we can allow for questions and answer within 15 minutes. If my understanding is correct, that the lecture is supposed to be for 1 hour. Thank you.
Oh, thank you so much, Lynette Silk. For this brilliant and deeply practical session. We have some questions, however, that have been asked by some persons even watching from our YouTube and also from here, Zoom. So we have to get together ready to respond to our questions. My distinguished guests, please, if you have questions, more questions, you can send directly to me or you can drop it at the chat box. Alene Silk is here to respond to every question that you have. Okay, someone was requesting for the case cited on tendering documents during cross-examination. Oh, okay.
Okay, that's the case of Gaji and Baye. I'll spell it Gaji against Paye 2003, 8 Nigerian Weekly Law Report, Part 823583. There are many of them. You can have also Akomolafe against Guardian Press, Akomolafe against Guardian Press Limited, 2010, 3 Nigerian Weekly Law Report, Part 1181. The same Law Pavilion cites Guardian Payeas 2003 Law Pavilion Electronic Law Report 1300 SC. So the authorities are plethora on that point.
Okay, Lynette Silk, thank you so much for that. So you have another question here. Someone said, how can a young lawyer develop the discipline to listen actively and adjust questions on the spot during cross-examination?
I will tell you something, right? With this front loading in civil proceedings, so you really do not need to take anything on the spot. It is sufficient for you to study the case in your office, look through the evidence, the witness statement on oath, and their pleadings, and documents that they have tendered, as well as your own document and your pleading and document you have tendered. See what it is you think from their document and the witness statement or note you could bring out to support your case. Note that down. See what you think are inconsistencies in the document and the witness statement on oath. Note it down too, and proceed to then go to court with that item to deal with it. Now, it is in criminal trial that perhaps maybe paying attention and thinking at immediately at the time the evidence is being given that becomes important. But even that, the yardstick for determining what you need to do is the offense that the person is accused of. Understand the offense. Note, because in criminal trial, you are allowed to do amendments of a charge, even on the day of judgment. It becomes critical for you to see that evidence not related to the charge is not led. So you be on your lookout to object to evidence not related to the charge. That's number one. Number two, understanding the offense upon which he is charged and the elements of the offense. That is what you'll be on the lookout for. How do you destroy evidence that they have led to produce the elements of the offense? If the elements of the offense are not proven by the witness, do not ask cross-examination questions regarding that, so that he does not, during cross-examination, come and build his case. Hello?
Yes, sir. That's a very insightful response, sir. So
Hello?
if we may take the questions further, someone is requesting, was actually asking that when in a criminal case where you do not have the case of the defendant beforehand, sometimes which requires asking questions you do not know the answer to. How does a lawyer get around that?
I thought that's what I just addressed.
Is
The charge is your instrument together with the section under which the offense is charged. So when you check the offense, okay, let's take the one that in criminal trial, what comes to mind? Culpable homicide, punishable with death, right? So what are the elements of the offense? That Mr. A is dead. So there must be a deceased. 2, that is the defendant that is accused of killing him. And then that the defendant did something which caused the death. Right? So these 3 elements must exist. As they said, actus reus mens rea, isn't it? So, and the principle is actus non facit reum nisi mens sit rea. Thus, where there is no mental element, there cannot be any offense. So the prosecution comes with a witness. He says, oh, I saw Mr. A. He was alive. He was hale. He was hearty. He was passing by, and immediately he passed through Mr. B's house. He fell down and died. I saw Mr. B giving him CPR. And after the CPR, they rushed him to the hospital. At the hospital, he said, oh, Mr. B has killed me. And he died. Fine. Good evidence. So your cross-examination question will now be tied as to what action did Mr. B do that led to his death. Right? So if you are not able to show any action that Mr. B did that led to the death of Mr. A, then there is no link. He's not been able to prove all the elements of the offense, irrespective of all the things that he says. Because for you, CPR is not what causes death, isn't it? CPR cannot cause death. So these are the things that you have to look at. Elements of the offense is very fundamental. I was in court recently. They were cross-examining a witness for money laundering. The evidence that was led in chief was that, oh, he bought a property. Portion of the property, he paid, say, 25% of it from his account. Then 75% of it came from another person's account. And then they said, oh, that here is the deed of assignment. It wasn't signed. Now, money laundering is that, okay, your attempt to come and hide either source of transaction, source of fund, and then maybe do transaction. So the defense counsel stood up and just asked the question. He said, this copy of the deed that you have that the defendant did not sign is your own copy. He said, yes. He said, you gave the defendant his own copy. He said, yes. He said, nothing further. Now, from that cross-examination, you would have seen that the cross-examination has shown that that document that is being tendered is not the complete document that tells the complete story. And in criminal trial, the burden of proof is proof beyond reasonable doubt. By that question, you have been able to cast doubt as to the authenticity of the proof, whether or not there has been an attempt at money laundering. Because it is not an offense that because I want to buy a property, I made another person to pay the money for me. So long as I identify that it is mine and I'm the person instructing, I have not committed any offense. So you have to understand the act, the offense, and then when you are able to show that, that's when you'll be able to cross-examine, even if that is right on the spot. I saw somebody said, oh, that yes, cross-examination, the sky is no longer the limit. I did not say that the sky is no longer the limit. I said to you that when you are in court and Every good advocate does that. He tries to prevent the adversary from scrutinizing his witness. And as such, he could stand up to raise objection and say, oh, my lord, this question is, though during cross-examination, is not relevant. Sky is no longer the limit. And I said, no, there is a statutory provision you can always rely on to ask the questions that you like, so long as it is within this remit. 223, and I'll read it again for clarity. When a witness is cross-examined, he may, in addition to questions referred to in the preceding sections of this part, be asked any question which tends to test his accuracy. So a question that tests accuracy need not be relevant to the matter in question. Say, for example, we are talking about whether Mr. A buys a car for a particular price or not. Then I start asking you questions as to maybe Nigeria's Independence Day, colors of Nigeria's flag. It's not related to buying a car, but it is aimed at testing your accuracy. Or I ask you, what year did Jonathan become president? I am testing your veracity. Or what color of clothes did the man wear on the day in question? Or I want to test your credibility. I say, are you not the one that when you were in secondary school, you were expelled from school for lying or for exam malpractice, for being dishonest? Were you not ever sued did you not sue somebody for defamation and the court dismissed the claim because they say you are not a honorable man? I can do that under section 223. If you go to discover who he is and what is his position in life, shake his credit by injuring his character, I could do that. And you cannot now stop me from doing that by saying that the sky is the limit in cross-examination. The famous authors Murphy on Evidence in the 12th edition, this is what they said. You see, cross-examination is a process whereby a party seeks A, to test the veracity and accuracy of evidence in chief given by a witness called for another party, and B, to elicit from that witness any relevant fact which may be favorable to the case of the cross-examiner. Cross-examination designed solely to discredit the witness and to destroy or reduce his credibility is sometimes known as impeachment and is perfectly permissible in its own right. Hello? So for those who want to prevent you from cross-examining a witness under the guise of saying that the sky is no longer the limit, my dear colleagues, please go to court with your section 223 of the Evidence Act. I hope I've answered that question. Thank you.
Thank you so much, Leonard Silk. One last question. Cross-examination often requires assertiveness, control, and quick thinking traits that can sometimes be misinterpreted when displayed by women in the courtroom. What practical strategies would you recommend for female litigators to confidently own the space during cross-examination while navigating gender-based biases that may arise from judges, witnesses, or even opposing counsels?
Okay, again, I say I am a he for she. You can see my he for she tag. But I don't really want to believe that you have there's really no style that is not acceptable. All the styles are very wonderful. So I have my master, Dr. Onyechikwe. If you go to court and you're with him, he's quite soft-spoken. He's very nice and polite to the witness. But sometimes the table could change and he could insist. and he insists in some cases that the witness must do ABC. Now, I understand that we used to have a lot of, difficulty in proving gender-based violence. So I'll give you an example. So a small girl was giving evidence that she was, defiled by an adult. And the lawyer cross-examining her said to her, "Oh, his dick is so big he cannot enter inside your vagina." She said yes. He said he had nothing further. So if the accusation is that he has committed rape, I think he has gone scot-free, because if there is no penetration, which is one of the elements of the offense, he has gone scot-free. But I think what is very, very critical for every advocate is that the advocate should know his style and he should use it. But what is very fundamental is that the advocate should not do it with ignorance. You are often stopped if you go to court without knowing the basis upon which you are doing the particular thing that you are doing. As I said, in cross-examination, you need to prove your case. And in trying to prove the case, you have to do it very well and with calmness. Now, I used to go to courts and I see some judges say, "You have 10 minutes. I'll adjourn your case." Please, if a judge gives you 10 minutes and in that 10 minutes you are not able to prove your case, please take an adjournment and come back. The reason is not far-fetched. If you rush to take that proceedings and you lost out in that proceedings, then you are done for. You will not prove your case, and then principle of res judicata will apply forever. Justice rushed, they say, is justice crushed. I do not think that now our ladies have anything inhibiting them from winning. My auntie Mia SAN, you need to see her in court. She's a maverick. And I don't think there's anything that stops anybody from, that. Our Mama Solanke, she used to tell us the story, how fondly when she goes to court, she does her cases and there are no issues. So I do not think any idiosyncrasy should be taken as a limitation in your ability to prove your case or conduct your case as you see it fit in your best manner possible. Thank you very much.
Leonard Silk, thank you so much for this insightful and inspiring time. Um, Even though I thought the questions were over, but this session has brought in a whole lot of interest from our guests. And one of the question, though this is a bit out of, okay, no, it isn't really, would like to know what books, both local and foreign, you'd recommend for cross-examination. Someone wants to know this. What books would you recommend for cross-examination tactics?
Okay, you see, I think for there are several books on evidence, and all of them they are very good. In my library, I have Sebastian Hunt's book. I have Akinola's book, Practice and Procedure. I have Murphy on evidence. I have Phipson on evidence. I have loads of book on evidence. There is a book written by my Lord Justice Oputa, The Modern Advocate. It's a very good book. I think there are just several books that you could. Fabian Ajogu and Mama Sholanke, they wrote a book jointly on cross-examination and examination in chief. I think those are books that one should get. Sometimes you could even get it from the biography or autobiography of very wonderful lawyers. When people are telling their story, they tell of the things that they did and all of that. That's where you can get all of that. But fundamentally, I think it's your understanding of the Evidence Act very well as to the limitations and then the prospect of the areas you can do cross-examination on. That is your fundamental tool. Every other thing, you could then learn it as you go. Some of them, you even ask them from your colleagues who are sitting close to you. I will tell you that many a times I will be in court talking about a point, and then somebody who is not even in the matter will just give to me a paper, and on the paper, he will write something very interesting. And that thing, if I utilize it, it will advance my case. Note, however, that it is not every note that you receive that is helpful. Some of them could just be dangerous. So just, play. But again, fundamentally, you should get those books, read them, understand what you can do with evidence, and then just go to the field. Understand your case. Because I cannot tell you that you should ask this particular question when that is not the particular fact in issue that is before you. Note, however, that a proper reflection of the case will assist you in knowing the questions that you should ask. Thank you.
Leonard Silk, some persons are raising their hands and they've dropped it. So I'm going to be giving 5 people the opportunity to speak during this session. If you know you want to speak, just raise up your hand. I'll pick at random, just 5 people to ask their questions directly. So the rule is you just have to be very brief and all of that. Don't give so many thanks. Just be brief and straight to the point. So I'll go first with Chinedu Kings. Yes, you can speak. You can unmute yourself and okay, you've dropped your hands. All right, Aisha to Abdullahi, you can speak. Unmute yourself and speak.
Thank you. Can you hear me?
Yes, very well.
So I'm a prosecutor, so I'm even happy to be here. So I've heard some of the things that the Leonard Soka said. Thank you so much for that. So no question per se, but it's very interesting that we also handle cross-examination. So it's been insightful and very appreciative of the books. That's it for me. Thank you.
Oh, thank you so much,
Thank you,
ma'am.
Aisha. Thank you very much.
Okay, we'll be going next with Selim Haliru. Selim Haliru. Yes, you can unmute.
Good afternoon, Sig. Hello.
Yes, we can hear
Good
you.
afternoon, Salim. I can hear you. Good afternoon.
Sir, my question is, in a situation whereby a lawyer intends to, sorry, I forgot to introduce myself. I'm H. Salim from Zaria Branch, sir.
Oh, nice
You're
to have you,
welcome.
Mr. Salim.
Yes, sir. Where a lawyer intends to tender a document during cross-examination, and the document sought or intended to be tendered is not the original, then must that lawyer lay a foundation through that witness as usual during examination in chief to lay a foundation as to the whereabouts of the original, then you now tender a photocopy of it? Or how do we go about that? That's my question, sir.
Okay, so Salim, that's quite an interesting question. Note that usually the man who will assist you to prove your case is not your adversary. So if the document you intend to tender through him is not in an admissible state, it is with simplicity, it may be difficult for him to assist you. But if, say, the original is in his custody, and that document is a document in issue. The Evidence Act says that the notice to produce is dispensed with, and it says the secondary of that document is admissible through him. So you could then tender it in that circumstance. Say the document is in his custody, he is not the adversary, but you have given notice to produce, then you are entitled to tender the secondary document because of the circumstances in which it is. Note, however, that all documents pertaining to their admissibility, they are regulated by the Evidence Act independent of the witness. So, if a document is a public document, for the secondary copy to be admissible, it needs to be certified. It matters not what the witness says, you have to do that. If the document is a private document, the circumstances in which they are to be admitted is regulated by the Evidence Act. It's not dependent on the person who is on the stand at the time. So that should be the answer that you can take from here, that it is the Evidence Act that will guide you, so that if you ask him and you find that he is able to tell you that, yes, the document, the original is with me, the original is at home, the original is somewhere, then you are good to go. You could then tender. But if it is not, he may not want to assist you. And if he doesn't assist you, you may lose the opportunity of tendering it. You know, as I told you in the Ofolete's case, the court said it is an opportunity for you to use it to prove all the things that you want to prove. In fact, what the court said was that it was suicidal for you not to use that opportunity and then attempt to use another person's evidence to discredit the evidence of a witness. So it means that if a witness evidence is not discredited at the time he's at the stand, the court said that you cannot discredit it in any other means other than that means. So note how to use the best example, the best opportunity that has been provided to you in the circumstance of your case. As I told you, I cannot give you a fixed answer because circumstances that play out in cases, they always change. You cannot even have two similar situations in cases because circumstances could just change, and then there are so many things. Like the prosecutor did tell us, even among judges, you know, a judge who comes from the prosecuting line, who is sitting on a criminal case, his attitude in that case will be different from the attitude of a judge who comes from the defense line, because everybody's idiosyncrasies are different. So also so you have to just be careful, but know your law, know the things you need to do to render it admissible. Make sure you do it at the time you are doing it, and that will be sufficient for you. I hope I've answered your question.
Thank you so much, sir.
Leonard, you are doing marvelously well, sir. So we
I'm grateful.
have
Thank you.
one hand, Hussein Hassan. Mr. Hussein Hassan, you can ask your question. Okay, Hussein Hassan has left, so that goes to Njoku Kletus. Mr. Njoku Kletus, please go ahead, unmute and ask.
Okay, thank you so much. I don't know if everyone can hear me.
Perfectly, we can hear you.
We can hear you.
Okay, my name is Sisi Njoku. I work with the Directorate of Legal Prosecution, Force Headquarters. So it's such an honor to be here because cross-examination is always a problem in criminal matter. So my question is this. What if I have a document that I want to tender through the witness? I've missed the opportunity of tendering it through maybe my own witness, and then the witness just made mention of the content of that document. I tried to tender it through the witness, and the witness denied having knowledge of that document. What do I do in tendering it? Or does it mean that the witness has refused to assist me totally? Then the second question is, if I have a certified true copy that I want to tender directly from the bar, Do I just make mention of the document and apply to the judge that I want to tender it? Or is there anything I need to do special?
Well,
Thank you.
thank you very much. Let's deal with the first one. So if the witness made reference to the document, you can tender through him. All you need to do is to go back to the evidence he'd given in chief, because I'm sure he must have said something related to it in chief. If he doesn't, I'm afraid you may not be able to, unless maybe you are able to show that that document relates to the transaction. So for example, you are dealing with a situation where you are saying somebody presented forged certificate. No, okay, that he wrote a letter in the course of committing an offense. Say maybe he issued a check to the bank for non-existing fund. Then after he has issued that check, he wrote a letter to the bank to say the bank should give him, otherwise he's going to cause his lawyers to sue them. Now you are charging him for attempts to defraud the bank. You had, in the course of your own evidence in chief, presented the checks that he wrote, but you didn't present this letter. Apparently, the letter would have come after you have closed your case. He is now in the witness box. So he has given his evidence in chief. I never wrote those checks. I'm not the one that did it. I don't know anything about it. So you could start by asking him questions that will make that document relevant. Probably in that letter he had written, there is an address. So you could ask him, is so-so and so place your address? Yes. Do you run so-so and so company? Yes. Do you have a letterheaded paper? Yes. Take a look at this letterheaded paper. Is that the company's letterheaded paper? Yes. Look at the content of the letter. Is it relating to this check? Yes. Let's do another set of questions, all towards this guy. One, the account in which you claim you have money is account number so, so, and so. Maybe he mentioned it in his letter. You say yes. That account name is blah, blah, blah. You say yes. Take a look at this letter. Is this not the letter you wrote pertaining to that? He may say yes. He may say no. If he says no, you could still ask him, look at the name there. Is that not your name? He will say yes. If, for example, there's a signature in the check you had initially tendered, you could collect it and say, compare this check, compare the signature and the signature you have in your hand. Does it not look the same? There could be an objection to say, my lord, he didn't come to say he's an expert witness. Of course, you should expect that. But you could also say, my lord, I'm just asking him to tell me the opinion that he has as an ordinary man who can compare two documents. I'm not asking him as an expert witness. So you see, you are ready. The opponent is also ready. Because me, if I'm there, I'll object, I'll say, he's not a signature expert. You too, you should have an answer to say, no, you could ask him those ordinary questions. So the scenarios can just be, a lot of scenarios can crop up. So it's for you to learn what is the logic you will use. I saw in a judgment where some judgment sentence says using the African sense. Sometimes you may need to use native sense when you are doing this business so as to achieve what you want to achieve. Thank you very much.
Thank you for doing
Thank you so
justice to that, Leonard Silk. Now the fourth person wants to know from our Facebook community that what will you say about cross-examining a digital generated evidence? That is the procedure of doing it, please. The person wants to know if how to cross-examine for a digital generated evidence.
I really don't think there is a species of cross-examining documents dependent on their sources. I don't think there is. It's the same procedure. There is no different species. First, if the document has ever been admitted upon compliance with Section 84 and the recent amendment in 2024, then you just cross-examine it. So documents are not, cross-examination are not dependent on the sources. No, they are not. So you just, I don't think there is any, unless the question I don't get clearly, but that is digitally generated or any other thing is not, there's no rocket science in cross-examining it. So long as what you need to achieve, if you want to discredit, maybe if they give particulars, you show that, for example, they say they printed from this computer, blah, 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 blah. So if you could query HP and HP says, we've never ever manufactured any computer with this IMEI number. That's your ability, that's you discrediting. But it has no, there's no genre of cross-examination for criminal cases, cross-examination for civil, cross-examination for election petition, cross-examination for aviation, cross-examination for maritime. There is no such thing. Cross-examination is unique and universal for all areas of law. It's on admissibility of documents and credibility of witnesses and all of that. That's all you need to know. Yes, thank you.
All right. Thank you so much, sir. Even though we've exhausted our 5 persons limit, we still have 2 persons hands on air. Sir, would you want to take those?
It's not every day. My only concern is that of all the questions that have been asked, is the he for she that we're asking. And I thought it's the she's that should be asking the questions. But I'm happy to answer any question that comes my way.
All right. So Onome and Seidu, you have, today's our Christmas day. Oh, one more person. Onome, you can unmute and ask very briefly.
Okay. Good afternoon, sir. Please, on evidence, where you tender, like the evidence act says that it's either original copy or a certified copy. Hereby, I have a copy, a document from abroad that is a foreign document that I want to tender in Nigeria. Should it be original or certified? That's my question, sir. Hello?
Yes, so you see the Evidence Act
says that
yes,
if you want to
thank you
tender
for
a
the question. It's very interesting. So again, you just need to look at the Evidence Act again. It provides for what you need to do in that circumstance. Though again, I will say that this is not the topic, but then let me just help you. It talked about the kind of that. Just a moment. Let me see if I can pull out the particular section that tells you even documents, foreign documents. Yeah, just read, please read section 106 of the Evidence Act. It's very detailed as to, yes, section 106, but you can start from section 102, and then you see what it says. It says the following documents are public documents forming the official acts or records of the official acts of the sovereign authority, official bodies, and tribunals, or public officers, legislatives, judicial, and executive, whether in Nigeria or elsewhere. So there's a criminal trial I am doing where somebody sought to tender a judgment from Dubai. And I objected on the ground that the document from this provision is a public document and it must be certified from Dubai before it can be admissible by the provisions of the Evidence Act. And the court agreed with me. There are even case law on that point. So that is the case. So you look at those sections, it's very detailed as to what you need to do. And I think you should just go through and look at it and you'll find that there is an answer to that question already in that section. Thank you very much, Onome.
Thank you so
You're
much,
welcome.
Leonard Silk. Seidu, you have the mic. Unmute and ask, please.
All right, good afternoon, Yolanda Silk. Hello, are you
Good
hearing me?
afternoon. How are
Good
you? I can
afternoon,
hear
sir.
you. Just that I'm not seeing
I'm
your
okay.
face. It's your beautiful cutting I'm seeing.
Sorry, Yolanda Silk.
Yeah.
Yolanda Silk, I have a question, please.
Yes.
There's a situation on ground where the persecutor, after serving you the pursuit of evidence they intend to rely on in court, then upon tendering same in the open court, you now discover that there's variations upon the copy they serve you and what they want to tender. Like let's say there's mutilations, maybe addition of name. Maybe when somebody, in name of FIR, in name of all the document they serve you with is Saidu Salifu. Then all of a sudden, they now wanted to add another name to it just for them to prove your case. So, sir, how will you go about with situations like this, sir?
There is the case, let me try and remember the case. Just a moment. Just give me a moment. I'll just give you a case and you can just go and read it.
All right, sir. Okay.
Yes, just a moment. Yes, there's a case, Omishori against Aregbeshola.
Sorry, yes, sir.
2015 Law Pavilion Electoral Law Report 24803 SC. It talked
Yes, sir.
about the admissibility of a document that has alterations, additions, in fact, including underlining. The court held that that is an addition to the document and makes it different. Perhaps maybe you could rely on those documents to, do what it is you think you can do regarding that state of affair.
Thank you so much, Leonard Silk. Seidu, I guess your question has been answered. Just hold on. We'll be moving
Yes, sir.
on to Oriogene Adewunmi. Please unmute and ask.
Hello, good afternoon, everyone. Good afternoon, Leonard Silk.
Good afternoon, Oriogene
Oh,
Adewunmi.
you got it right. I'm very, very pleased about that.
I'm
All
a
right, so please,
Nigerian.
sorry, please. In all honesty, this question is kind of unrelated to cross, but I feel since we have you here, if we could just ask, if you could be so kind as to please give
I'm going to
give an
send my
answer,
legal bill. I'm going to send my bills for
and I will
export.
gladly pay it, sir. So please, sir, I just
So
want to
thank you.
ask. In some of my colleagues have come across this situation in court. I want to ask about bank statements. Is it the case, or rather, is it not the case? Because I know before the advent of Section 84, before the requirement for certification of computer-generated documents, it was the case that you had to certify bank statements and so on and so forth. Now that there is Section 84, do we still have to get stamps from the bank and so on, and for the bank to stamp each and every single page? The reason I ask is there's a particular judge that I appeared before. Of course, I will not mention his or her name. And the judge keeps saying that if you do not, the judge has rejected documents several times. Well, not from me, but from my colleagues, saying that they did not certify it. And by certify, I mean going to the bank for the bank to stamp, to put on the stamp that, it's from Keystone Bank or GTB or Polaris. But my thinking is that since the bank documents, or since bank account statements are a computer-generated document, immediately you provide the certificate as required by Section 84. That should suffice. So I just wanted to get your, respectfully, if I could get your opinion on that, or your answer on that, which is the right. Do you still have to go to the bank for them to skip stamping, or would Section 84 suffice? Thank you, sir.
There's this case of Dixon, I think Dixon and Silver. Dixon and Silver, 2016, Law Pavilion Electronic Law Report 41257. That case determined two questions. First, the admissibility of electronic evidence and the need to certify public document. In that case, what was sought to be tendered was a printout of a newspaper publication. So the court held that that newspaper publication, by virtue of the Library Act, which mandates that those newspapers should be deposited with the chief librarian, that those newspaper publications are public document, and as such, they will require certification. The court now also held that in addition to that, because they were online publication, they require compliance with Section 84 of the Evidence Act. Now, if you read Sebastian Horn, particularly his second edition, he is of the view that electronic documents that meet the requirement of Section 84 should be admitted simpliciter. I should think that if the statement of account is generated online, as we used to have, because everybody knows that now by our apps, you could have them. But you know, those statement of accounts, they have another problem. They are not signed by anybody. And you know what the authorities say about unsigned document. Perhaps my Lord is taking into combination those two states of affairs, the case in Silver and this Dixon and Silver, as well as this requirement for signing of a document to hold that you need to fulfill two conditions. So I think maybe you should read that law, that case, and then see whether, because again, I want to admit that was talking about newspaper publication. I don't have any case handy on statement of accounts, but it seems to me that there exists a decision of the Court of Appeal that says a statement of account that complied with Section 84 simpliciter will suffice. In the cases I have done, you will see that the statement of accounts abide by both Section 84 and have an officer of the bank signing for authentication. So I've not come across this kind of state of affairs that you have. So I've not had reason to research on the particular case to be able to provide a direct answer for you. But I should think that these cases should be able to guide you on how to navigate that problem. Thank you.
Thank you very much, sir.
Yeah, you're welcome.
Okay, thank you. I see all hands has been done justice to. Oh wow, not all, but
so
please,
I think maybe if
we have to
take
temper justice with
Victoria
mercy
and
now.
Macaulay,
Yes,
Abby,
and we are done.
we
Yes,
can
sir.
take Victoria and Macaulay, and then we stop.
Yes,
Yes.
yes. So Victoria, please, the floor is yours.
Okay, thank you so much. I am really glad to be here this afternoon. Thank you, Leonard Sick. Thank you, all the organizers. My question goes this way. Sir, you said something about that you yourself, that you like to ask or use objective to ask questions. And
yes,
from my little practice, I think I see myself aligning with that side. I don't usually write my questions. I don't know why. Even if I write my questions and I come to court, I see myself deviating from the questions I ask. Is it that I rely more on, should I call my own logic? If that is my own, should I say, my own kind of practice, can you help me throw more light on that area. I find myself helplessly not using the questions I have already prepared before coming to court, which means subconsciously I align myself with your own practice, which is asking objective questions during cross-examination. Since that is my own line of practice, could you throw more light on how I can enhance it more? Because sometimes I come out from the court asking myself, oh, why didn't you ask this? Oh, why didn't you ask this? I just focus on on the witness. I try to psychologically, throw them off balance. I try to discredit their credibility and their veracity. Since I found myself in that line, can you help me grow that side?
Okay, Victoria, thank you very much. I think it's just simple. So for me, for example, so this is what I do. I say, I write objective. I want to get maybe 4 objectives. Say, cause the witness to admit that he is indebted to you. So that's objective number 1. Cause the witness to admit that you have made demands and he has not paid. Cause the witness to admit that you could charge interest on that debt, and cause the witness to admit the day that you made the demand. Now, these 4 objectives is what I go to court with. And these 4 objectives, it is the scenario in court. Because sometimes I may not have seen the witness, I've not psychoanalyzed, I've not tested, so I don't know him. So I go to court, I look at him, he's well dressed. And then as he's talking, he sounds really educated. So I look at my objective, and now it is from there that I'll now frame a question that will help me achieve my objective. Once I achieve those 4 objectives, I go. The problem with question writing is that you must have to get all those questions ticked. The problem with them is that if you elicit answers that are not the answers you expect, you may not be able to reframe a new question to achieve that answer again, because you have already have the question the way you want to frame it, and then you have lost it. Now, let me tell you another danger. You could have typed that question, you print it out and you put it inside your case file. Unfortunately for you, as you are going to court, that question falls off. You are in trouble. But what is even worse for you, say you go to ease yourself and your opponent sees the question. He calls the witness aside and tells him all the things he should answer. You are in trouble. And those things do happen in court. So you have to, I thought maybe you should have the objective, write the objective down, and then make sure that you have achieved the objective before you leave the witness. Don't be in a hurry to release the witness. Thank you, Victoria. So that's just the simple thing. Get the objective that you want to achieve and then write it down. And then from there, frame questions you want to use to ask the question so that you achieve that objective. Yes. I hope I've
All right,
answered the question. Yes.
Yes, you
And
have.
it
Let us
is
hear.
developed in a day. We keep practicing, developing, learning. Learning is a continuous act. So we just keep doing it. Yes. Okay, Mr. Macaulay, you are up. Last but not the least.
Thank you so very much, Learning Sick, and
You're
the
welcome, my
organizers.
dear brother.
Actually, I
Yeah.
put up my hand. Yes, I'm calling from Epoma in Edo.
Ah,
Yes, I actually
my
put up my
people.
hand to appreciate the Learning Sick and the organizers. This lecture has been most exciting and most inspiring. I've learned so much from this interaction this afternoon, and I want to commend the organizers for this opportunity. Thank
Mr.
you, and
Macaulay,
God
you are
bless
very
you all.
kind. Thank you very much. Thank you very much.
Okay. So I think that would be all from the hand raising. However, Leonard Silk, I have my own question. And my question, my question to you is very, very easy. It's very simple. Nothing technical
I
at
hope
all. So
yes, go on.
mine will be on a broader reflection of things. After all your years in law and in law, still in law, what does mastery mean to you personally?
So I don't know. That's even, I think that's the most difficult question actually. Mastery. I think mastery, if you're watching when I was very young, we were watching Bruce Lee. So every time you go to they go to their training, they will see that the master is still, doing some practice. And if you remember recent Kung Fu Panda, always the little bear, he's always practicing, always learning. So I think mastery is the knowing that you have not achieved it yet and you need to continue learning it so as to achieve it. So it's a continuous, insatiable hunger to achieve excellence, which is a pursuit that is a lifetime pursuit that shouldn't stop at any time. I think that is what is mastery. Because if you remember Bruce Lee, he was a master in whether kung fu, but yet he always goes to the training hall to do it. And I've forgotten the name of the guy in Kung Fu Panda, but he was always, practicing continuously. So we should just continue practicing until the end of time. It shouldn't stop. I remember Chief Williams. I think it was when he was celebrating his 60th year in practice. I remembered he was taken, there was a shot of his whilst he was reading, and they asked him, what does he want to achieve? And he said he wants to die reading. And you can imagine what Chief Williams achieved in this practice. And yet he said he wants to die reading at his 60th anniversary of being a lawyer. So that is what I understand as mastery, a continuous, insatiable quest to achieve mastery. I hope I'm not I'm not doing tautology. Thank you.
Not at all, sir. Before we proceed, ladies and gentlemen, it is with great pleasure and honor to acknowledge the presence of a distinguished personality in our midst. A man whose impact on legal education and the Nigerian bar cannot be overstated. He's a life bencher, the Director General of the Nigerian Law School, a teacher and an exceptional administrator whose leadership continues to shape the next generation of lawyers. So we are truly privileged to have you here with us today. With your kind permission, would be most delighted to hear a few words from you, just about 2 minutes, to bless this session with your wisdom as well and presence. Ladies and gentlemen, join me in welcoming the Director General of the Nigerian Law School in person of Professor Isa Hayatu Chiroma to make a brief remark.
Senior Advocate of Nigeria, you didn't add SAN in it.
I'm
That
so sorry,
introduction
sir.
is not complete.
I am so sorry, sir. So please, sir, we'll
Indeed,
just
you are highly welcome. And it's a big honor. I didn't know you were here. Perhaps I would have done better research. I can't be speaking law when you're around. But it's a honor to have you all through. You're welcome, sir. Yes, sir.
so I don't know if he's ready to speak. He's right here in our midst, but he's not saying anything. Okay, we'll go back to him so we don't further waste any more time, today's session has been deeply practical. There is no table that wasn't touched and no stone that wasn't turned. It's brilliant, and our learned silk here has opened the floor, like a very big floor, for us to see that this thing is something we need to know, and then it is something we need to master, even though mastery is in the learning. You keep on learning even when you think you know it all. So from understanding your own psychology to understanding the psychology of your witness to mastering the rhythm of your questions, truly cross-examination is an art from that demands preparation, patience, and intuition from you, and as well as from your witness. So we've taken questions, and all questions we are dealt with, really dealt with, and we'll be rounding off here. This webinar was supposed to be an hour, 30 minutes, but we have over an hour, 45 minutes. So as we begin to round off, it's only fitting that we hear once more from our host, a woman whose leadership and dedication made today's event possible. Ladies and gentlemen, please welcome Haja Hadiza Afebwa again for her vote of thanks. Haja, are you here?
No, yes, I'm with you. Wow, you can see me beaming from one side of the mouth to the other one. Today is actually a very, very great day. So I would like to begin by acknowledging the presence of our revered DG Nigerian Law School. Oga, we call him Oga Ayatu Chiroma. It is a huge honor to have the DG with us, the learned SAN. So distinguished learned senior advocate, Mr. Abdul Mohammed Rafindadi, SAN, and all gentlemen of the bar here present. I thank you very much for being here. And as we conclude today's webinar on the art of cross-examination, its mastery and tactics, I would like to, on behalf of the chief host, Awela, and the leadership of the FCT chapter, thank and express our heartfelt gratitude to the Learned Silk. We are truly grateful, privileged, and honored to have you share from your vast reservoir of knowledge. This is no, I would like
I must
to
thank you.
to us.
I must thank you for inviting me. I always
Thank
like
you,
joining he
Leonard
for
C.
she, and I'm very grateful. Thank you. Thank
Yes, thank you very much. The learner Sikh is one of our biggest he for she. We drag him every time, right from school when we were in school together. That and him the name the Colossus. He's still a Colossus, is growing huge and huger by the day. And then this is a generous guru. Always available to explain to us, taking tutorials. So this is for familiar terrain. It is a natural calling in him. We thank you for coming and for sharing great insights, great knowledge, and great experience with us. And I'm sure the participants have benefited hugely. Learner Senior Advocates, sir, we will want to plead passionately. You have been doing, like Oliver Twist, we are going to ask for more. So we want to plead with you, please, to always be available for our events, and to always open your doors for us, because definitely we are going to come calling all the time. In less than 9 minutes, we had already reached the limit of the participant we can take. Your expository, we call it lecture, all the authorities you gave us, you shared freely, both statutory authorities and judicial authorities are invaluable. They are immeasurable. We thank you so very much. And then we thank you for having us. And then to the moderator, the webinar researcher, we are so grateful that you brought up a topical issue which has, how will I put it, which has made it possible or exposed all of us here to the art of cross-examination. You will agree with me that we have learned a great deal today. So I thank the ICLE. I hope they are here. You people from the ICLE, give us generous CP diesel, give us generous one, because we did not make noise, so the learners will be able to witness. We were very good students. We didn't make noise. We didn't speak vernacular, so we need bonus. Thank you. I'm just kidding. And then to the participant, I thank you very, very much. I can see my seniors here. I can see my colleagues, Mahmoud, Dindam, Aisha, Ibrahim. I can see a lot of people, Fatima, Mustafa, Maria. I cannot call everybody. And then from our guests that, joined us from other states. Somebody spoke from Ekpoma, Mr. Macaulay, some from Zaria, some from everywhere. We really appreciate you, and we hope we have been able to satisfy you. And we appeal that you stay more. You continue to join us as we continue to bring more engaging and topical issues, and we'll call learned people, experts in the field, to come and share their experiences with us. So your participation this afternoon, it makes it very, very worthy, makes the event a very worthy one. And I thank everybody for coming, and continue to stay with us. Learners say, God bless. Thank you.
God bless you, Leonard Silk. And from all of the comments we are having today, there's one that really I really wanted to hear, because you may not see all of them. So one person said that you answer your questions with so much precision, expertise, and you are very, very good. So I was wondering what they were thinking. A whole Leonard Silk. Is our Leonard Silk not supposed to be the best at it? So thank you so much, sir. Thank you, everyone that took out time from their busy schedules to be here today. Your presence cannot be bought. Your presence is invaluable. Your presence is everything. We appreciate you and we thank you very much. So, on behalf of the Nigeria Bar Association Women Forum FCT chapter, I say thank you again and have a wonderful day ahead. Thank you, everyone.
Thank you, able moderator. Thank you, everyone. Stay safe.
Thank you very
Bye-bye.
much, gentlemen. I'm happy that you had me. Have a nice day. Bye.
Bye, guys. Bye, everybody.
Bye, Leonard Seal. Thank you.
Thank you very much.